by some sort of review or report?
My learned friend actually, Mr. Salty Casey, actually made mention of the review and the report.
Oh,
but
right.
What is significant?
Check my notes. Right.
Right. What is significant that comes from it is that, and we take pride in this. And I'm quoting. I'm paraphrasing our Chief Justice, and it's found. Thank you. It's found in the written case at 12 and 13. Yes.
Right. Thank you.
Yes. But what we, as I was saying earlier, we take pride to say that this amendment, which is separate from any other Caribbean jurisdiction, was for us. It was made by us, and it was a testimony of our evidence of independence.
Yes.
Where we decided what rights would be protected, and especially the dynamics of the Jamaican society.
Yes.
Is the importance of protecting the least among us.
And was it intended that it be developed? I suppose was it meant to be what you might call an autochthonous Bill of Rights, if we can call it that would be developed by the Jamaican judiciary in light of circumstances in Jamaica, or was it intended to be influenced by comparative human rights jurisprudence looking at other charters of rights and constitutional guarantees in other countries?
I'm happy that you asked that question, because we did look, and I'm saying we because I take pride in being Jamaican, but we did look at other jurisdictions such as South Africa, and if you even the Canadian and the United States. But what you'll see, a clear indication, and again, my friend is indicating that it's in the written case at 20 and 21.
Yep.
But what's significant is that what is clear is that there is, similar to in the Canadian jurisdiction, that the test, which is the demonstrable justifiable test, is mandatory once there is a breach. And before us now is that there was a breach. The learned judge, and I will say this respectfully, this came at a time when the charter was very young. And so the contemplation to give effect to it, as judges do in interpreting the intent of the legislature.
Yes, and I see paragraph 13 draws our attention to what the Chief Justice Sykes has said, that it's autochthonous, which means it's indigenous, homegrown, originating with us rather than imposed from outside. Yeah.
And what is key, which I will get to, and I agree with you, and I adopt the words of our Chief Justice, is the fact that after looking at constitutions all over the world, what we decided is what is important to us. So what we have is a section 13.2b, and I know there are many persons, I quote it so much that it becomes an annoyance to many, but 13.2, the protection given to every citizen under 13.2b. It is the last flicker or shimmer of light to what it is to be a human. And it separates the state clearly from the human being. And it says, listen, all state actors have a duty not to abridge, abrogate, or breach the rights. And when you do that, you must show that it is demonstrably justifiable. So in an answer, yes, thank you. So in an answer to that, ladies and gentlemen, that balancing exercise as to the evidence when it was asked about, especially in relation to what was on JS2, doesn't even begin to come up until after the judge would have carried out that exercise of the demonstrably justifiable test, and he did not do it. So we have nothing on the record as to any submissions from the state, from the Crown, to say, here, notwithstanding, it is justifiable. There were less restrictive measures, or here's why there is a breach. So we don't have that before us, and that is the one flaw in the judge's acceptance. And he evidence of that is he was concerned. He made words to my senior, Mr. Taylor, who is in the room, that if he was not daunted by the change in the charter, and the significance of it, the response at that level was nothing much changes even after the concession. But we do recognize the importance of it, but to submit to the court that the test wasn't done, and so there's no balancing exercise to which could have happened. And because this is our apex court, the apex court could not respectfully substitute what the judge at first instance ought to have done. And in those circumstances, the answer to question A, where evidence was collated, collected, and secured. So secured would have been the request from the police officer. The collection and collating would have been what flows from JS2, the cell site, the text messages, the call positioning, whatever flows from JS2. But all of that would have been no moment. And a key thing before I depart, because I don't want to take up too much time,
you don't have a great deal of time left.
I was being cheeky, Lord Reed, but I didn't know you would figure me out. But the key thing in relation to that aspect is to understand that as we make heavy weight of JS2, what's incumbent on the judge was that in a demonstrably justifiable test, I would submit respectfully that in the absence of JS1, which was the controlled copy that the police officers did not have access to, and where the much counsel from the lower level, which Tom Tavares, KFC, would have said, listen, this is a man from Ireland would have come to Jamaica, not given any effect to the right, and he gives testimony. This is Simmons, and he doesn't say whether he knows exactly what's in each and every file, and we have nothing to cross-reference, so they would have failed on that test. The last thing I will say before I take my seat, the Lords and the lady, is in relation to the trial, the jury point, is I certainly, and I've read for this case about 4 years, in relation to the jury point, it has never been in the modern common law where a jury who we know for a fact is poisoned, is tainted, was allowed to remain on a jury, to bring a verdict, simply because the legislation would have prevented him from being discharged, where it is clear on its face that that juror ought to have been removed to protect the fair trial right. And it is in that vein that I will say that there is no cure, no proviso, or no thought of a retrial or a second bite of the apple where the unfair trial right was breached in the manner that it did in the circumstances from incident 2 to incident 3, and then the justification for breaching what we know is common practice in the Jamaican space to ensure that you leave one sentence so that the deliberation takes place on the next day. And that would be my submission, that the conviction should be quashed or ought to be quashed, and I trust your wisdom on that. Thank you.
Thank you, Mr. Buchanan. Well, if we've heard all counsel on behalf of the appellants, then I'll turn to Mr. Knox. Now, Mr. Knox, I don't want to knock you off your stride before you've got started, but it would be helpful to us if you were able to address us first on the jury issues, and then we may consider whether we need to hear you on the JS2 issue.
My lord, yes. Doesn't knock me off my stride too far. But I have to read my handwriting, as opposed to the typed. Can I go first with the first of the jury questions that remain? And go first of all to E4072, 4072. Which is in bundle 5A, if anyone's working from a hard copy. Now, I would just like to show you what happened, has been called in, about a third of the way down the page. Now, she didn't present the case for the prosecution, but I'm told by her, she's in court at the moment, Ms. Paola Llewellyn, that when this incident arose, the judge called for her, if she was available, to come along, as did indeed the deputy DPP. And so she turned up, because obviously this was a difficult incident to know what to deal with. So you see there, 5166, she's come along. And then you'll see what she suggests at the foot of the page, 5166. Judge, it's dependent on what your lordship decides. Clearly that's the issue. We'll have to go to another domain. That's between her as the complainant, a particular person. If there's to be credibility in the matter, that's not for you. It's a very serious matter. So she's not encouraging the judge, so to speak, to make any further investigations into this. I submit quite rightly. Judge, if that report is credible, and having heard the thing, one decision will have to be made in respect of that man today. He's going to have to make up his mind now. DPP says yes. And then the judge says, this is all very painful. But I'm going to have to arrange for Madam Foreman to come into the into chambers. You see that about two-thirds of the way down the page. And then the Madam Foreman...
Do we assume that during that period of time, who else has been? Is there any indication who else is with Judge and the DPP?
I think all counsel, I should say, as I understand it, all counsel are present, but not the appellants themselves. I don't think there's any issue on that.
Right. Thank you. Doesn't actually tell us, does it?
You're right, my lord, but I have a feeling, I don't think it's in contention.
Thank you.
And before he says that he's going to call Madam Foreman, he says that he's going to summon that juror, and he's had instructions to the police.
Yes. In fact, he never does.
Yes.
But he does get the Madam Foreman along. And so she turns up. I'm now at 5167 at 2:43 p.m. Judge, you can see what the judge says, 5167, line 19. And if you can, maybe simpler, my lords, my lady, if you read on to 5173, rather than me picking out bits here and there, because there may be other things which I miss out, which you might want to read.
Sorry, to which page?
5173.
Thank you.
And then I'll make some comments on it.
Yes.
My lords, my lady, if you're ready, if I can just draw particular attention to the following points. First, at 5168, my learned friend is quite right, and he says, the contact was made with me today, so she finds out today. However, the contact has been made over a period of time with other jurors, and they confessed it to me. However, I cautioned them and told them that we are going solely on the evidence. I told them not to be swayed, that's the word, not to be swayed with what is being said, and they cannot be intimidated by what's been said either. So they're okay. And then she goes on to say how the bribing juror got in touch with her and seemed to be frightened of her at first, or frightened to do so at first. The second point is at 5170, at the top of the page, he called me out. That's bribing juror. We were in the room. He said he needed to talk to me in the jury room. I asked him what he wanted to talk to me about. He said to me that he knows that I'm influential and people listen to me. I said it's not about listening to me. It's based on whether I pointed them to the facts of what we hear, not to be influenced by what is outside. He said to me, well, he needs me to do him a favour. And then dropping down, I asked him what was that about. He said that we should go to lunch. I said, no, I can't leave because I have things to do and I have somebody coming to me. Basically, he said, I should convince everybody to release, and then, in answer to my Lady Simler's point, the men at the bar, not at the bar. And then over the page, 5171, judge asked of the forewoman, you knew him before you came on the panel? No, I met him here. But when we met, that's when my suspicion of him grew. We started watching and observing his actions from there, because initially he was mad. They chose me as the foreman. He went to everyone and tried to ask them to make him the foreman instead. And basically goes on to say, it's a duty, and we don't, being the foreman doesn't mean I'm going to have tea in the judge's chambers, eat crackers and go for lunch, which is a duty. So that's what she's saying. So what she's saying, essentially, is he seems to have gotten to the head that he wants to be, as it were, the big chief. He's disgruntled about this, and she just took no notice. But importantly, towards the end of 5171, but over time he recognised that, okay, fine, before he started going to these persons and telling them that, listen, this is what we need to do, I would say, you are listening to the evidence. He said, no, we just need to let go de men, again, them. So when we speak today, he said to me, that's what we need to do. And he says she says the conversation went on for 5 minutes, and she repeats the £500,000 figure. Then towards the end of 5172, he says, as Mr. Southey rightly pointed out, Madam Foreman, 11 of us. He spoke to 11 of us. That would probably suggest, therefore, the discharged juror. He spoke to 9 persons first. The thing is, nobody's listening to him. Because nobody's listening to him, he wants me to speak to them. I do emphasise that. So I'm not listening to him either. That's the reason why I got him on tape. But the trouble was, the tape wasn't particularly clear, so it never got played. And then you'll see at Madam Foreman leaves at 2:52 p.m. Now, I emphasise that because she leaves in advance, and the summing up doesn't resume, I think I'm right in saying, until about 3:20. So there's plenty of time for her to inform, because she's bound to inform the jurors of what has happened, that she's been to see the judge in chambers. And you'll see 5173, the DPP Says the judge, I wonder if you can allow each team to discuss for 5 minutes. I will wish to speak, and I'm sure my learned friends will wish to speak, perhaps 5 minutes. So again, the reason I emphasise this is there was time for the appellants to speak to, or rather the appellants' counsel, to speak to the appellants themselves. And then the DPP, towards the foot of 5173, recommends to the judge just warn them again about their oath, just their oath. That is what she is suggesting. And then over the page, Mr. Finson, Tavares Finson, you'll see 5174, the DPP at the top, repeats, as far as the prosecution is concerned, we're prepared for the matter to proceed, just remind them of their oath. And then Mr. Palmer's counsel, we're of the view, don't see how you can proceed in these circumstances where you've got one person who is making an allegation that someone's going around offering the jurors money. She obviously has some tape, her role. So he seems to be objecting, not on the basis that, so to speak, there's a corrupt juror who is on their side, but rather he's rather concerned about what the forewoman is saying. But in any event, Ms. Llewellyn then says, the DPP says, in fact, it's the prosecution who is most at disadvantage by carrying on. And in my submission, that's obviously right, in principle. There's one person who obviously wants to let these people off. There is a risk that he is going to be persuading others, or has persuaded others. And then you'll see at the end, at 5175, the matter ends at 3:07 p.m. And what happened immediately after that is when the summing up resumes, the first thing the judge does, I think I'm right in saying, is remind the jury, if I can just dig up my reference, I hope this is right, 5149 at 3:22 p.m.
Just remind me, Mr. Rogers was representing who?
I think it's St John.
Right, so you've got Mr. Finson not exactly agreeing with the...
Finson's for Palmer.
Yes, I see. But you've got both Mr. Finson and then Mr. Rogers raising, on the face of it, objections.
Concerns, yeah. I would have to accept. They're saying we're not very happy about this. And I think one of them says, I'm concerned about the overcompensation point. And maybe Mr. Rogers says there's a risk of overcompensation. That is to say, the jurors will swing too far in favour of the prosecution because of their knowledge of the bribery attempt. Can I just mention one point before I go to what the judge does? I should have made it before. It's not clear whether, and there was no investigation, whether or not the bribe was coming from the appellants themselves. And that's why I mentioned the figure of £2,700 equivalent. It may just be this particular person was, and don't forget we're talking about very famous people, he's a particular aficionado, we don't know, of Mr. Palmer's and Mr. Campbell's work. But in my submission, what the judge has done, subject of course to points of law, is in my submission, again, very difficult circumstances, but perfectly sensible. He's called in the relevant parties, and on the face of it, the party most affected by the problem, the prosecution, is saying, I'm prepared to carry on. And the reason, of course, for that is that this is day 56. In practice, it will be, or may well be, very difficult to get a retrial of this matter. Another 56 days, you're going to have to get Mr. Chow to come along again. I would hope that you could take judicial notice of the sheer difficulties, certainly, in relation to some of these witnesses coming along again and arranging things. So on the face of it, it's the prosecution who's saying, I'm prepared to take this risk. And the first thing that then happens, going back to page 5149, is the judge reminding the jury at lines 3 to 13 of their duty.
He doesn't say there that they shouldn't hold anything against these appellants.
No, he doesn't. But, my lady, I would submit it's obviously implicit. I mean, the context here is that the forewoman's been called over to see the judge to talk about the bribery, and she's been told to go back and tell the jurors to deal with the matter in accordance with their oath. And they, of course, will know about these allegations of bribery, because it's said that the bribery has been offered to all of them.
So he can delegate his duty.
Well, my learned friends like that. But no, I'm not saying he can delegate his duty, but it's quite clear that he's taken a favourable impression of the forewoman, and it's quite a sensible way. He's not delegating, but he's saying to the forewoman, you tell them, as you have been already, you decide in accordance with your oath, and then he reminds them of exactly the same thing when you get to 5149. I agree he doesn't mention, and my lords, one can see why. He doesn't specifically mention, I gather someone has been bribing you. He's in a difficult position, whichever way he goes. And I submit it's a perfectly fair thing to say, I'm reminding you of your oath. It's an oath to decide in accordance with the evidence. And the jurors would have known that was their obligation.
Sorry, which page were you on when you're saying that he immediately tells the jury?
5149. The summing up resumes at 3:22 p.m. 5149. So the first thing he does is tell the jurors after the break, which everyone knows what it's going to be about. First thing he says, decide in accordance with your oath. In my submission, economy sometimes, just making the main point, is the best course. And this, in my submission, is a perfectly reasonable course for the judge to adopt, because everyone knows what he means by this. Can I just also emphasise that subsequently, at 5157, the judge repeats the direction he had already given, but importantly, he repeats it in accordance with their oath. They're not nincompoops.
Can I just ask you, in the context of your submissions, do you see any role for the Porter and McGill test?
It's fair to say that where I'm putting it is that the question is whether there was a fair trial or not. And in my submission, if one could be satisfied that there was a fair trial, that is that. I mean, in one sense, I accept that what I'm saying is that if the court is satisfied there was no risk of well, in one sense, Porter and McGill is to do with a real risk of possibility that the tribunal is biased. But it's not the appearance so much, but there is a risk of possible bias. And to that extent, I accept Porter and McGill is right, because in my submission, what the judge did was to remove any risk of possible bias. It's not quite the same way as the Putnam test, but it comes to much the same. But appearance of bias per se, I submit, is not the relevant test. The question is, was there a real risk or possibility of bias?
And you say he removed that by the direction he gave at 3:22?
And also by what he'd been telling them before. It's the whole thing has to be looked at. It's often said in the cases that the judge is entitled to look at, the judge, in making these sorts of decisions, will bear in mind his view of the jury, so far as he can tell, over the course of the hearing. And in my submission, he was entitled to take into account also what the forewoman had said to him. And I do submit, if one asks, and looking at everything, if one looks at A, the verdict, B, the letting off of Shane Williams, and C, the evidence, which I'll come to later if I may, which is simply overwhelming, one asks, what unconscious bias, so to speak, added to all the evidence which was there anyway? How could it have done? And that is the point about the strength of the case. One can see where the evidence is equivocal and so forth. One might say, well, that's rather harder to tell. But if it's 2 and 2 equals 4, well, there is in my submission a basis for saying the risk of a possibility of bias it has been removed, was not likely to have affected the jury's verdict, or won't have affected the jury's verdict. Can I just take you to the Bonnet and Taylor case? Because it is important at this point, to what extent can you trust the jury quite properly and in accordance with their oath? And we looked at one passage already. It's at 6291. Paragraph, I think I'm right in saying, 6290 one can begin at, paragraph 24. There was, however, another course that the judge could have taken, and did take in this case. That's say, not making further inquiries about the juror. At the outset of his summing up, he gave the usual direction to the jury. It was for them to decide what evidence to accept and what to reject. He then gave this direction: decide this case on the evidence and only on the evidence. Do not be influenced by anything you might have been told by anyone, whether by some fellow member of the jury that sat or are sitting with you about some prior knowledge or feeling or view. That is unimportant, and if you act upon that, justice will have miscarried, because that's not the evidence. I hope that I'm making myself absolutely clear that it's the evidence and only the evidence in this case that you have heard that you're entitled to act upon and determine. Having looked at the evidence, examined it, weighed it, determined what facts are, and ultimately what your verdict is, after applying the law, and I will give you to the facts that you find proved. Now, I agree that's a stronger warning, but nonetheless, it's to the same effect. Then, the important passage in paragraph 25. The assumption must be that the jury understood and followed the direction that they were given. See, a judgment of my own, as it were. In the Supreme Court of Canada, in Corbett, Chief Justice Dixon said that the experience of trial judges is that juries perform their duty according to the law. In the High Court of Australia, in Blenheim, Mason CJ and Toohey J said that the law proceeds on the footing that the jury, acting in accordance with the instructions given to them by the trial judge, will render a true verdict in accordance with the evidence. To conclude otherwise would be to underrate the integrity of the system of trial by jury and the effect on the jury of the instructions by the trial judge. In the Irish High Court case at Z, Hamilton P. expressed confidence in juries to follow the directions given to them by the trial judge. The direction which the judge gave in this case was clear, understandable, to the point. The board is satisfied that it was sufficient to deal with any risk that the juror who was excused might have said something that the jury ought not to have been told. Now, of course, my lord, everything turns, in one sense, on the facts of a particular case. But I do submit it as a fundamental principle that you trust the jury to act in accordance with their oath. And it is implicit both in the judge's decision to leave this matter to the jury and in the Court of Appeal's decision that they were satisfied with their knowledge, if I can put it this way, of how juries work, that they would have done.
And does it matter that, I mean, inevitably you're focusing on the 10 because he didn't trust the 11th. He had the police ready. He said he had the police ready.
I accept it. That goes back to my answer to the first part. I accept he probably doesn't.
Does it matter for these purposes that effectively he's trusting a jury of 10,
yes,
and 10's not a jury within the Jury Act in Jamaica, is it?
One then gets into what I call a rather metaphysical argument about what is a jury. Clearly, it's 11 people who walk into court. I go back to what I call the first question. Is it really the case that there is no jury if it turns out afterwards that one of them had taken a bribe and was going to acquit come what may?
That's if it turns out afterwards.
Yes.
What if you know going in?
If you know going in, I submit the same follows.
The same.
The judge is entitled to say this: a 10-1 verdict is a good verdict. It's authorised by law. I have good reason, I'm just, as it were, expressing in words what no doubt the judge would be thinking. I have good reason to trust the 10. They will follow my directions. That is good enough to satisfy the requirements of the statute, that there be a jury who decides this. Because there are 11 altogether, and if there are 11 altogether and one of them still takes no notice of what I say, well, so be it. But my Lord Reeve put the point at the beginning. It's quite a short point, but quite an important point. But I do submit the crossover between these two questions does arise, but I suppose it's very important to keep them separate. Because if I'm right in saying that a verdict by 11 men, or 11 men and women, one of whom is bent, is a good verdict at the time, then that's a good verdict. If, on the other hand, it's clear that there's a real risk that the 10 might have been influenced by the one, then I accept that might be a basis for setting aside the verdict.
Just starting with the one, you say that the judge can choose to leave somebody on the jury, notwithstanding that he knows this person is corrupt. Presumably it's the same if he knows that the juror is mentally ill or communicating with the deceased via a Ouija board or has been looking up the internet. It's the same, is it?
No. No, my lords, it wouldn't be the same. If I may, no. The important point here is the prosecution knows the problem, and in the passage I took you to, the prosecution says, we're the ones taking the risk.
Well, but they can't waive there's a public interest in the administration of justice. It's not a matter...
Well, the difficulty, my lords, if this had happened on day one, it would be a very different position, obviously.
You're really just postponing the question. So, on your view, can the prosecutor decide that it's okay to allow somebody to remain on a jury, notwithstanding all the scenarios that I've put to you, and the judge can go along with that?
In my submission, in the extreme circumstances of this case, yes.
And how many jurors can the judge allow to remain on the jury, notwithstanding his knowledge that this one's mentally ill, that one's been bribed, the next one's in touch with the deceased via a spiritualist?
Well, no, of course, he can't. Right. The whole problem in this case arises because there were just 11 left. That is where the problem arises from. And my lords, of course, I can see one can think of any number of examples, like the Lordship is putting to me, saying, well, in those circumstances, surely the prosecution couldn't just waive it. But this is rather different. This is right at the end of the trial, enormous expense, 56 days, the evidence has all come out, the summing up has been done, and then, boom, one thing comes out. Now, in my submission, the question is simply this. I mean, it does get to this point. If I'm right in saying that a verdict of a 10-1 verdict of 10 good people and one bent person is a good verdict as a matter of law, then the judge is entitled, and the prosecution is entitled to say, well, I dare say that person won't obey his oath, but I'm satisfied the other 10 will.
But that's assuming there's going to be a conviction. The jury has, if it's going to acquit, is going to have to do it by, is it an 11-person jury is going to have to do it by a 10-1 majority. And how does the court, the judge know, well, it's likely that there will be 9 good people and true and 1 crook in the 10, it's an acquittal.
Well, my lord, if in my submission, the judge, the fundamental right is to a fair trial for the defendants. If the prosecution, and in one sense, this whole case comes down to one point. Can the prosecution say, I know there is this one person who seems to be offering bribes, we probably can't trust him, but I'm prepared to carry on and take that risk. Is it open to the prosecution to do that? That is the question. That's what the prosecution did. And in my submission, the answer is yes. There's no authority, if I may, with great respect say, that says, no, the prosecution cannot do that, because that would deprive the accused of an unfair trial. I also make this point. The question is not, so to speak, at the very moment this all takes place, but looked at broadly, looking at that verdict. Have the defendants received a fair trial? If one is satisfied, the 10 were not influenced. I agree, obviously, that's the separate question. But assume for the moment that the 10 applied with their oath, they acted properly. Is it really to be said that that was a bad verdict and the defendants must be acquitted or the appeal must be allowed? I submit no. That, I do firmly say that would bring justice into disrepute. 10 people have done their duty, 1 person has messed it all up, but the verdict is a good verdict at 10-1. Why does it matter if the one has brought disaster That brings the jury system into disrepute. Our learned friends, of course, rightly say that in England we don't have that problem. But this is a common law point. And the question is, what is the common law in this situation? And that's why I urge upon your lordships the point that I'm making. I fully accept you've got the separate point about who knows what was going on in the back of the jurors' minds. That's a different point. But my point is just on this, what you might call the degree to which there have to be 11 people on the jury. The fact is there were 11 people on the jury. That is my short answer to this. One of whom, at the time, there was good reason to suppose wouldn't act properly, and who we now know didn't act properly. I submit that's not a conclusive answer. And
Can I just take you to, where we got to, I think, which was paragraph 25 of the Bonnet-Taylor decision, page
Yes.
6291.
Yes, thank you.
Lord Hope very clearly says that the direction which the judge gave in this case was clear, understandable, and to the point. And we look either earlier at what was being put forward as the defence, as the direction.
Yes.
Don't allow anyone that you sat or sitting with about some prior knowledge or feeling or view, that's unimportant. In other words, he's directed the jury to the specific problem. Now, just to say you've got to carry on with your oath seems to me non-specific. It is not to the point. It doesn't make clear to the jury precisely what the judge is wanting them to do.
In my submission in this context, it does, because they will all know there's been this half-hour break in the summing up. While Form has been called away, she will have told them, because the judge says, tell the others, she will have told them what's happened. And, my lords, I fully accept, of course, one might say the direction could be more forceful. I accept that. But the question is, was it sufficient to ensure the fairness of the trial, given everything else which I've mentioned? And in my submission, it was.
But all I'm saying to you, putting to you, is that what was said by Lord Hope hardly supports your case, because this was not a specific direction.
Well, my lord, not express. I don't want to, as it were, quibble. I accept it was not specific, and of course, it would have been better were it this specific. But the question is, was the direction given by the judge taken together with everything he had already said, and the juror's sense of responsibility, was it sufficient? But of course, this is a different point. My submission is it was, in one sense. I take your lordship's point. It's not specific in the way this was, but in my submission it was sufficient.
But I'm not sure that it. I think you probably have dealt with this point, but it strikes me. But when you say this is a question of common law, I don't think it's purely common law, because we do have the statutory provision.
Yes.
It's on page 6803.
Yes.
Which tells us that 12 jurors formally array in a case of murder, and then says in subsection 3, where in the course of a trial any member of a jury dies or is discharged by the court through illness or other sufficient cause, the jury shall nevertheless, so long as the number of its members, so it's a proviso, so long as the number of its members are not reduced by more than one, be considered as remaining properly constituted. Now, it might be said that the judge, as it were, can't sidestep that provision by failing to discharge somebody where there was indeed sufficient cause to discharge them. If he discovered, for example, that the person, the person had been bribed, or was the defendant's brother-in-law, or whatever you like.
Well, in my submission, that wouldn't be the correct construction of this. In one sense, you have my point. As long as there are.
I mean, you were saying it's just a question of counting the number of live bodies on the jury, and
that's all it's saying.
Yeah.
Well, my learned friends, my submission, that's what it's saying.
Yeah.
Yes. And my lord, after all, one doesn't know. I mean, at the time the judge gives his direction, he decides what to do. He might be hopeful hoping against hope, so to speak, the miscreant juror will actually just see sense. But it doesn't follow, in my submission, from this act that the judge is bound to get rid of that juror. That's the question. But I agree, if he's bound to get rid of that juror, he's bound to bring the case to an end for that very reason. And this is why it is a short point, but in my submission, a difficult and interesting point. I haven't addressed you on the proviso and things like that, but I'm conscious of the time. But I wouldn't mind showing you some of the evidence. I mean, it is, because I do connect it to my point. Well, there was no need for any, if I can put it this way. Anyone looking at the evidence would say, I couldn't care less about these bribes, so what? I've seen it with my own two eyes, type of thing. Forget the bribe.
Yes.
But I'm conscious, my lord, I'm preying on your time. I don't know how you want to proceed. I see what the time is now.
Well, obviously you have more time tomorrow. We perhaps, speaking for myself, the point you've made about how you could find out after the event that a juror was corrupt. And the question then is if the other jurors had voted 10-1 to convict, completely ignorant of the fact that would the verdict nevertheless be vitiated, and it would have to. And I think if it were, it would be on the basis that we've been discussing, that there is, as it were, a non-quorate
non-quorate point, really, yeah.
Which suggests it may suggest that the point we made earlier, the point I made earlier about based on. Seraphim may not be quite as obvious when you have 11 judges, as it were, as it is where you've got one judge.
As in that case.
Well, shall we leave it there, Philip?
I'm so sorry. The case that you mentioned in Strasbourg about the racist members of the jury, do you have the reference?
Mr. Turnbull has the reference. It's Gregory v. UK, at page 7914. And I have a feeling there are two other cases which similar issues arose, which I cannot quite remember. If you give me one, sorry? Sander's one of them. Is there? And there was another one too.
There's a Russian case, which is not exactly on point, Tinkov.
Oh yes, there's the Russian case, that's right, yes.
8373.
At 8373, thank you.
Very well.
Sander is
Sorry,
7960. Thank you.
Well, I think we may have reached a convenient point to adjourn for the day. We'll consider where we are in relation to the JS2 point ourselves, and we'll look forward to hearing the remainder of your submissions tomorrow, Mr. Knox.
I would like to.